Welcome to Talking Feds, a roundtable that brings together prominent former federal officials and special guests for a dynamic discussion of the most important political and legal topics of the day. I'm Harry Littman. From its high perch, seemingly impervious to the protests of colleagues, the legal community, and the American public at large, the 6 members of the ultra-conservative Supreme Court majority loosed several term-ending thunderbolts that violently altered the legal and political landscapes in this country and increased the prospects for a disastrous return to power of Donald Trump. The court reserved its loudest proclamation for the final day of the term, issuing a long-awaited opinion on presidential immunity from criminal charges. It is no exaggeration to say that Trump versus United States reconfigured the tripartite structure we all learned about in 3rd grade and placed the president, any president, firmly above the law and all other Americans. The first impact of the ruling was definitively to eliminate the prospect of a trial for Trump this year on charges of attempting to hijack our democracy after the 2020 election. In a flurry of final opinions, the court also upended administrative law in a manner that will immediately impact all Americans' lives, bolstering the federal court's authority at Congress's expense. And it sheepishly dismissed an abortion case, putting off until after the election the prospect of a follow-on to its hugely unpopular Dobbs opinion overruling Roe v. Wade of 2 terms ago. Coupled with Joe Biden's disastrous debate, the court's actions have left our nation's political and landscapes as unsettled as they've been in generations, while raising the likelihood that Trump will evade all accountability for his historic transgressions. To come to grips with what the court has done, how it has transformed our constitutional democracy, and the many aftershocks that may follow, I am happy to be joined for our annual end-of-term review by 3 of the country's most trenchant analysts of the court. And they are Emily Bazelon, staff writer at the New York Times Magazine, co-host of the popular podcast Slate's Political Gabfest, and a lecturer and Truman Capote Fellow at Yale Law School. Before coming to the Times, Emily was a senior editor at Slate, where she co-founded the women's section XX. Her newest book is Charged: The New Movement to Transform American Prosecution and End Mass Incarceration. Thanks, as always, for joining Emily Bazelon.
Thank you.
Melissa Murray, the Frederick I. and Grace Stokes Professor of Law at NYU, the faculty director of Birnbaum Women's Leadership Center, and a co-host of Crooked Media's Strict Scrutiny podcast. Melissa is an author of Cases on Reproductive Rights and Justice, the first casebook in the field, and she writes regularly for national publications and provides commentary for national media outlets. Melissa, great to have you with us, as always.
Thanks so much for having me, Harry.
And Steve Vladeck, I think I may be the first podcast host to be able to say this, a professor at Georgetown University Law Center, where his appointment just became official this week. Steve is also the Supreme Court analyst for CNN and co-host of the National Security Law podcast. He is the co-author of the leading national security law and counterterrorism law casebooks. His book, The Shadow Docket: How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic, was a New York Times bestseller. Thanks, as always, for joining Talking Feds, Steve.
Thanks, Harry.
So, going right to the immunity case, before we actually get into just what the court said, the basis for the court's decision is our constitutional structure of separated powers. In what sense is the court's analysis a separation of powers analysis? It's really the DOJ, part of the executive branch, that is being told to stand down. So how does that fit in with what the court says is the driving force of separation of powers?
The opinions about the separation of powers in the sense that it separates most of everyone else from the president's power, and in the sense that I think it reallocates a remarkable amount of power from Congress and to a lesser degree from the courts to the executive. I mean, I think it is about the most pro-executive power majority decision of the Supreme Court that we've seen in a very, very long time, if ever. And I'm worried not just about what it means for efforts to hold future presidents accountable, which is, I think, obviously the top line, but at a more basic level, just how future presidents are going to use that opinion as an effort to dodge congressional oversight, as an argument against the constitutionality of statutes purporting to restrict the executive's power, as an argument for why executive branch officials and not just the president should be immune from everything from criminal prosecution to compliance with subpoenas. It really opens a Pandora's box that I think goes way beyond the specific question of presidential criminal liability in general, or even Trump's liability specifically.
I mean, that's a really good point. It is a separation of powers opinion. It's just that sort of dignifies it and makes it sound like there was some like jurisprudence of separation of powers that the majority opinion by Chief Justice John Roberts is drawing on, when in fact it feels like almost entirely made up, right? I mean, Roberts concedes that the historical sources are fragmentary. And then what he's doing, at least in spirit, is very much, I think, in tension with or even contradicting United States versus Nixon, our most important bedrock, Watergate precedent, which says that, like, yes, President Nixon did have to obey a subpoena in a criminal case. He was not the one under indictment, but he tried to invoke executive privilege. And famously, the Supreme Court then said, no, 9-0. Now we have this other case, and I think that I very much share Steve's sense there is this top line concern, and we should talk about that, but also it seems to kind of vastly state the powers of the president in this way that I just find kind of astounding. I just don't know why we want to live in this world where we have this unbounded president of the United States. It just seems like a bad idea, and is certainly not required by the Constitution.
It's not at all required by the Constitution, Emily. I mean, it's completely anathema to the constitutional design that the framers orchestrated. When they got together in Philadelphia in 1787, they were principally concerned with constraining the authority of A, Parliament, and B, the king. And they were worried that if either of these two institutions could consolidate power, arrogate power to itself and consolidate it, they would have the means of being tyrannical. And they knew of what they spoke. Like, they had seen a tyrannical parliament with the Stamp Acts and all of the intolerable acts that had precipitated the American Revolution. They understood what a king could do if he had absolute authority. And the whole idea of separation of powers was to separate and give each branch of government its own lane so that they could stay in that lane and not assume the prerogatives of others. The idea that we would insulate the president almost entirely from a congressional law that prohibited certain kind of conduct as criminal would have been anathema to them. And so, yes, I guess this is a separation of powers opinion, but it's a very strained and ahistorical reading from a court that purports to adhere to history and tradition.
Maybe I was too cute in posing the question, who did something wrong here according to the court? Was it really Congress in passing generally applicable laws for obstruction and bribery, and that somehow trenched on the core powers? Or was it the executive branch applying the law to the president? It certainly seems to me that it's the latter. Another way of stating this concern is there doesn't seem to be any kind of traditional separation of powers analysis. It really seems to come down to the court's notion of what is a good idea for the vigor and aggressiveness of the president.
I actually thought that the majority opinion and Justice Thomas's concurrence were really interesting in their celebration of this idea of a nimble, energetic, vigorous president. And what it reminded me of are the opinions in Youngstown, which is a very canonical separation of powers case involving President Truman's seizure of the steel mills during the Korean War. And in that opinion, the court says that Truman has gone too far. He's appropriated the authority of the legislature for himself and has violated the separation of powers. But there are a number of concurrences, and famously there's Justice Jackson's concurrence that talks about the 3 tiers of presidential authority. There is another concurrence by Justice Douglas that talks about the need for a vigorous, energetic president, but also recognizing the need to be cautious about a vigorous, energetic president. And he contrasts the nimbleness of the executive with the slow-moving deliberation of a multi-member body like Congress. Congress cannot move quickly. It must be slow. It must be deliberative. And the president is much more nimble, much more agile, which is why we should be concerned if the president can take and arrogate power from Congress or some other branch to himself, because he has the agility to actually put that to particular purposes for his own purpose. And, this is a decision that's announced in the late 1940s. Who are they thinking about as this nimble, vigorous executive who is charismatic and can arrogate power from other branches to himself and suddenly become despotic? It's Hitler, it's Mussolini. Like, that's who they are imagining as this agile, energetic executive, and they are rightly concerned about it. And that was not lost on me as I read Justice Thomas and Chief Justice Roberts celebrating this idea of executive vigor. That's exactly what the Youngstown court was trying to limit. They didn't want the president to be so agile, so nimble, because they understood that it led to tyranny, it led to despotism.
Yeah, I mean, I was thinking, Melissa, about what is the problem that this opinion solves? Well, it's really good for former President Trump, 100%. But also, do we live in a world in which our problem is that the American president doesn't have enough power vis-a-vis Congress, vis-a-vis anything? I mean, other than the Supreme Court, maybe, see the various opinions attacking the administrative state. No, that's not the world we live in. We live in a world of a dysfunctional Congress in which, the executive branch takes lots of actions that seem to have lots of vigor, nimble energy, whatever, behind them. And it's as if the court has blinded itself to all of that reality, as well as the reality that Trump was not a normal president, right? Coursing through the majority's opinion, Trump gets the benefit of the doubt, basically, in every scenario, as if he were a normal president, and that's just really hard to square with reality.
I mean, if anything, right, the history since Youngstown Tube has been precisely of the executive's aggrandizement at the expense of Congress. And then there's, just an irony that somehow they think they're, as Gorsuch put it, writing for the ages. Before Trump, we've never had a whisper of a problem of this sort. What in history and tradition or anything in the constitutional scheme suggests that absent freedom from criminal exposure, a president can't execute his actions with sufficient nimbleness.
But I think it also speaks to how this court views itself. And I think, part of what we saw, not just in the Trump immunity case, but in so many of the other major rulings this term, is a court that just doesn't think anybody can or should tell it what to do, and doesn't think anyone's in a good position to tell it what it should do. That includes even the code of conduct back in November. We'll adopt this code of conduct, but you can't tell us what to do. I mean, Alito literally said last summer to the Wall Street Journal, Congress has no power to regulate the Supreme Court, period. And I think if you start from that mentality and you apply it to the presidency, you end up in much the same place, which is no one can tell us what to do and no one can tell him what to do except us, because see Rule 1, right? So
Yeah, right.
Rule 1, we are supreme, right? Rule 2, the presidency is supreme except for Rule 1. And it's worth stressing who gets cut out of that. And who gets cut out of that is Congress. Congress gets cut out of that with regard to passing statutes to regulate the presidency. Congress gets cut out of that with regard to delegating power to administrative agencies. Congress gets cut out of that with regard to passing statutes that prohibit things like machine guns. And then the courts decide for themselves, well, something that basically acts like a machine gun isn't a machine gun. And what this is all about, Harry, at the end of the day, is about power. And power that the court claims it's reallocating for democratic purposes, but the reallocations are all to decidedly anti-democratic forces, whether it's the courts themselves or presidents. One last thing about the presidency. I mean, the court loves to indulge the fiction that the president's democratically accountable. That's a heck of a lot more true about a first-term president than a second. A second-term president is not much more democratically accountable than the courts are. And I think knowing as they did, or at least suspecting as they did, that we're heading for at least someone's second term, maybe that will change between now and November, that's a remarkable statement for the court to send at this moment in American history.
I think Steve is right, and you cannot understand the immunity case without also thinking about it in the context of all of the cases really undermining and hobbling the administrative state. And Steve's exactly right. Those cases are about arrogating power from Congress to the courts to make decisions about regulation. It's about arrogating power from the executive to the courts to make decisions about regulation. But most profoundly, it is about limiting Congress's ability or narrowing Congress's ability, requiring Congress to speak with a certain kind of specificity when it comes to what it allows executive agencies to do with regard to regulation. And there's this really interesting moment in the oral argument in Loper, Bright, and Relentless where...
The Chevron case, yeah.
Yes, the Chevron case, where Justice Brett Kavanaugh noted that we should be skeptical of the prospect of the executive acting as a king. And he was referring specifically to the executive acting through administrative agencies, like delegated authority from Congress to the executive to administrative agencies to regulate. And this was king-like behavior, according to Brett Kavanaugh. And then with the same breath, the same conservative supermajority that overrules Chevron on the ground that executive agencies regulating is king-like literally created a president come king in the immunity decision.
I just have a question about the power analysis. I find parts of this so surprising. Okay, we have some straight up MAGA justices on the Supreme Court, right? I mean, we had all these calls for recusal of Thomas and Alito on those grounds. I did not think of Chief Justice John Roberts as someone who wanted to spend the social and political capital of the Supreme Court on this. I thought the project was eliminating the power of the executive branch to do regulation, right? So I found all of that unsurprising, but this seems like different to me.
On the PowerPoint, I saw this as kind of a Kavanaugh and Roberts this term returning to the halcyon days of the formation of the Federalist Society and that the whole kind of platform that they had then, including the indifference toward whatever the reaction would be. And Steve, you wrote a whole Substack on this, but the very first reaction people had when this came out was, this is even more expansive than I thought. And I think it's another way of saying Kavanaugh and Roberts have maybe moved right and without apology. And is that the capsule sort of description?
So my face has no chill. Your listeners can't see it, but I'm like big eyes, lots to say. So one, Emily, I think we have got to stop talking about John Roberts as this stalwart institutionalist, because his institutionalism is incredibly limited. When it counts, he's not an institutionalist. This is the same guy who has written the 3 opinions that have done the most to undermine democracy in the history of our country, certainly in the last 50 years. He is the author of 2013 Shelby County versus Holder. That is a case that literally dismantled the pre-clearance formula of the Voting Rights Act. He is the author of 2019's Rucho versus Common Cause, a decision that said there's no role for federal courts to play in policing partisan gerrymandering, making it a literal free-for-all for legislatures to gerrymander with impunity. And now he is the author of this decision, granting the president sweeping immunity from criminal liability. And again, when it counts, he's dismantling democracy, and we cannot ignore that. He's constantly subverting democracy. Like, one of the reasons I thought this opinion was taking so long, I mean, just to be clear, I've said this before, but the delay in taking this case and deciding it granted Donald Trump de facto immunity from the January 6th election interference case. But this decision sets whoever is the president in 2024 up for an entire term of nonstop criming with impunity, whether that's Donald Trump or somebody else. But I thought that the reason why the court was taking so long was perhaps because John Roberts was insisting on unanimity for this decision. We have seen this before, Brown versus Board of Education, where Earl Warren insisted on a unanimous decision. United States versus Nixon, where the court was unanimous. For these big kinds of decisions, the court has often been unanimous. And this is a court that has been unanimous this term. I mean, there have been lots of separate dissents and concurrences sort of belying that consensus, but they've been unanimous, and I thought they would be here. The fact that John Roberts got a traditional ideological fracture on this decision and didn't seem to care about it, was not interested in brokering a more modest, restrained opinion, says everything you need to know about where he is and whether he is or is not a friend to democracy. I think the history books are going to put John Roberts and Roger Taney, the infamous Chief Justice who brokered Dred Scott, on the same page.
What's striking to me also about all of this is where Justice Barrett ends up, because it's not just her narrower concurring opinion in the Trump immunity case. It's not just her narrower concurring opinion in the Colorado ballot disqualification case. Her dissent in Fisher, the January 6th obstruction case, I actually think it's a mistake to not talk about Fisher in the same breath as Trump, because really what is striking to me about the Chief Justice's majority opinion in Fisher is not that it's analytically bankrupt. I mean, yes, the textualists don't care about text. We sort of knew that already.
Though we do appreciate learning it over and over again.
It is willfully politically oblivious. I mean, right, that like the opinion which hands, let's be clear, a very modest victory to a very small subset of January 6th defendants never tells you that, right? Never actually says, like, what happened on January 6th was bad, and the Justice Department is within its rights to throw the book at everybody who was involved. Like, it takes Justice Amy Coney Barrett in the first two paragraphs of her dissent to say, wait a second, like, let's talk about what we're doing here. And what I'm struck by is, I'm not surprised that this is coming from Alito and Thomas and Gorsuch. I'm not surprised that Brett Kavanaugh, who before anyone had heard of Christine Blasey Ford, was controversial because of how extreme his views are about presidential power, right? Like, those four votes don't surprise me. What surprises me is that Roberts didn't have to do anything to appease them. This was his. He was the median. And when you have Amy Coney Barrett saying, why are we pushing this far and this fast? You know, I would have thought that she's an even more powerful voice to slow them down than people like me, but apparently not.
Well, she was also like this in the disqualification case. I mean, you know, there was a unanimous per curiam decision, but she made clear she thought that the conservatives were going too far to decide questions about the scope and substance of Section 3 of the 14th Amendment that they didn't have to do. As a matter of judicial restraint and judicial modesty, they didn't have to go there. And she called that out too.
And in the immunity case, her position, if you're just thinking like, oh my God, how does Judge Chutkan in this case against Trump proceed? It seems to me, and I'd love to hear your thoughts, that if Barrett's concurrence had a majority opinion behind it, you would be able to see that roadmap, right?
It's in the footnotes. All over the footnotes of Barrett's concurrence is, hey, Judge Chutkan, here's how you handle what we've just given you.
Exactly, but it's only her talking, so we'll see, right? And she would have provided a way to introduce more evidence that could actually prove the allegations against Trump. Whereas, like, I remain very befuddled about what kind of evidence the court ultimately, because there are going to be a bunch of interlocutory appeals, right, about Judge Chutkan's evidentiary rulings. And I just don't really understand, because the majority took off the table anything that probes Trump's motive with regard to dividing official and unofficial acts, took off the table testimony or personal records of Trump and his advisors. I just am like really confused how the Justice Department proves its case now.
Well, can I say something about the evidentiary point? On that question, the Chief Justice in the majority opinion says very clearly that any evidence that pertains to immunized conduct cannot be used to establish conduct that is prosecutable, that is not immunized. And Justice Barrett departs from that, writes a long footnote about why she thinks that goes too far. So it's only a 5-justice majority on that point. If Justices Thomas and Alito had recused themselves from this case, as I think lots of people believe that they should, given their associations with the insurrection or being slightly insurrection adjacent, there would have been no majority at all. And Justice Barrett's opinion, I think, would have been the majority on that evidentiary point, and it would not have hamstrung the prosecution in the way that Emily is describing.
I just want to put a period on the discussion about Barrett before leaving, because I take your points to be not that Barrett is somehow moving left, but rather that Kavanaugh and Roberts, the putative center bloc with her, has itself moved right in a way that she couldn't countenance.
If you're going to read one opinion of Amy Coney Barrett's from all term, read her dissent in Ohio versus EPA, where she just takes a blowtorch to Justice Gorsuch's majority opinion and doesn't just tear it apart analytically, but also is like, what are we doing here? Why is this what we're doing? I don't think she's turned to the left. I think she's the rarest of rare birds. She actually has principles, a number of which I don't agree with, but principles that she's actually going to try to apply as faithfully as she can, even when it leads her, for example, in Fisher, right, to want to uphold Section 1512. I mean, so I don't think that's a commentary on Barrett so much as it's a commentary on how the court moved around her. You know, I have a piece coming out in the New York Times that basically says the story of the term is that Justice Barrett came out of her shell and the other Republicans retreated into theirs. That's really the story, that if you want to sort of put those side by side.
I mean, to me, it's less how she's voting and more what a plain speaker she's willing to be. She's willing to call out the conservatives when she thinks that their reasoning is inconsistent, even when she's joining in the result. So it only goes so far. But when you're looking at the reasoning, when you're us trying to look at reasons and what people are actually saying, it's like something to latch onto.
I agree with everything that's been said about her. I don't think she's moving to the left at all. I think Steve is right. She is a stalwart conservative, and what she is insisting on is a kind of judicial modesty that is completely absent from the court's conservative bloc right now, and that's what she's railing against. But I am 100% with Emily. Like, don't get it twisted. Like, she doesn't use her voice all of the time, and there are a lot of places where it would be useful for her to say something about that question of judicial modesty, and instead she kind of toes the party line. And I'm thinking specifically of her separate writing in Moyle, the EMTALA case, where the court dismissed that case as improvidently granted, saying that basically in the 5 months since the court granted cert on that case, they suddenly came to the conclusion that they ought not to have granted cert, that their review was improvidently granted, and they kind of punted on that decision. And she wrote this very turgid opinion in which Brett Kavanaugh joined, trying to explain how circumstances had changed. And it was long, it was turgid, it wasn't entirely persuasive that the circumstances had changed. Nothing had changed since the court literally leapfrogged over the Ninth Circuit to take that case. They were so hot to trot to completely excise EMTALA and allow the Idaho abortion law to prohibit the provision of emergency abortions. And they were hot to trot to take it. And she tried to explain why it was clear that now, with reflection, they shouldn't have taken it, but nothing was different. And she wasn't really, I did not buy her explanation of how much things had changed, because nothing had changed. Women were still being airlifted out of Idaho. There is an entirely different conflict in Texas between this federal law that requires federally funded hospitals to provide emergency abortions and a state law that prohibits the provision of abortion care. And she didn't talk at all about the conflict that continues in the state of Texas, which has an enormous population of women of reproductive age, even as Idaho women now get the opportunity to seek emergency abortions. Like, the court punted on that case, and it was an enormous dereliction of duty that was likely inspired by the court's desire to get the abortion question out of the electoral discourse before November 2024. And she tried to explain it away, and she did a poor job of doing it.
Yeah, Melissa, I had the experience when I was reading Moyle. I was like reading along on Barrett's concurrence, dissent, whatever it is. And I was like, oh, okay, well, so maybe there isn't such a big conflict between Idaho's position and the federal government's position. Okay. And then I read Justice Jackson's opinion and I was like, oh my God. Like, it just makes it so clear all the points you were making about the deficiencies with Barrett's approach.
And what I find especially galling about, I mean, just to sort of echo Melissa, the court jumped so far over everybody else in the EMTALA case, and that's consistent with the through line. Like, no one can tell us what to do. We're not going to follow normal procedural rules. We're going to exercise power when we want and not when we don't want. And, you know, here's a moment of buyer's remorse, and you get this just mealy-mouthed opinion about why, as opposed to like an honest concession that, like, yeah, we goofed.
Well, no, we didn't goof. We just realized that we cannot go into an election cycle with women talking about abortion and women dying in parking lots and expect the Republican Party to prevail. That's really what they're worried about.
It's funny because they say, almost with a little bit of umbrage, that they're not paying attention to the newspapers and they're doing notwithstanding current events. But it's really true. In addition to what you said about little crumbs set out for Chutkin, what the hell else was Justice Thomas's separate opinion in the immunity case other than a roadmap for Judge Cannon to use where that very thing has been raised? They have a kind of disingenuous, I think, attitude toward what's right in front of their face, whether you conceptualize it as Trump's heinous conduct or as the obvious role of what they're doing in the election. Oh, I wanted to add one thing about Barrett, which is the Rahimi case. So in the Rahimi case, she, I think, speaks the most plainly about the level of generality issue that hovers over all the kinds of substantive due process analyses. And the court really did splinter on that point. Do you think it spelled a kind of end, Rahimi, to the whole lockstep history and tradition analysis going forward, or only in Second Amendment, or only in, this case alone?
I mean, I don't think it's the end of anything because they were all writing their own separate concurrences. My take from Rahimi is we're not going to give the guns back to the really bad guys. He's a terrible plaintiff. He was going on a shooting spree. No. But it didn't answer the question for me of trickier Second Amendment cases, much less other domains of law like the 14th Amendment and religious freedom that have been also caught up in this new history and tradition / cherry picking galore test.
It's also, I'll just say, Rahimi is one of at least 3 high-profile examples this term where the conservatives couldn't all agree on what originalism even is. If you add CFPB and Vidal versus Elster, the Trump too small trademark case, here you have 3 opinions where the court is largely of the same view as to what the answer is, but you get separate opinions from Thomas and from Barrett, or in one of them from Kagan, joined by Barrett. Barrett tries out a new term, original contours originalism. I don't even know what that is, right? And it seems to me that the point, Harry, is not that there's some emergent coalescence around a particular brand of originalism. There clearly isn't, which is going to cause all kinds of mischief, not just in the gun cases Emily mentions, but in other contexts. The point is that the whole cell of originalism is that it is like the one true God, that it's an objective, unitary method for resolving constitutional debates. When the justices who are on putatively the same side can't agree on basic methodological questions about what that means, it might be time for us to admit that originalism is not what it purports to be, and that it is a tool for interpreting the Constitution, but it's not the tool because it isn't even one thing. The lasso on Rahimi, Harry, of course, is also not for nothing how bad a term the Fifth Circuit had, too.
When we did our curtain-raising episode, we basically cited a well-known conservative saying this is going to be the biggest term ever for conservatives, even more than 2 terms ago with Dobbs. And we pointed out how the Fifth Circuit was going to take its lumps, but we were both right? They really did take their lumps, and yet this is an absolutely colossal term for the conservative movement.
Well, here's why both can be true. So on our podcast, Strict Scrutiny, we refer to the Fifth Circuit as a meth lab of conservative grievance, where they literally cook up the most outlandish and extreme versions of conservative legal thought and then bake them into opinions and then send them up to the Supreme Court. And Steve is right, as he was in your term opener. There are a number of cases on the docket this year that came from the Fifth Circuit. The Fifth Circuit serves a vital role for the Supreme Court Public Relations Office because the Fifth Circuit essentially exists to be so extreme and off the wall that the court must reverse them. And when the court does reverse the Fifth Circuit, it gets the opportunity to look moderate, to look reasonable, to tack back from the far right to something that's really more sort of center right. And other people talk about them as though they are moderate and reasonable when they're doing this. But in fact, coming back from where the Fifth Circuit was only makes you just a little bit more still makes you conservative. Like you're tacking back from something that's so extreme and out there that you're still firmly in the conservative wing when you tack back. And so the court is still incrementally moving to the right. It's just the Fifth Circuit is so far out there that reversing the Fifth Circuit, rebuking the Fifth Circuit, chiding the Fifth Circuit makes the court actually look good. I will say, though, I did love the various rebukes to the Fifth Circuit. Justice Kagan got some zingers in, like, obviously this is crazy and we can't trust the Fifth Circuit to actually do this case right when we send it back. So here's some real guidance for them. I also loved how the Chief Justice rebuked the most auditioning federal appellate judge in America, Jim Ho, who is constantly trying out to be the replacement for Clarence Thomas if Donald Trump wins the election and Clarence Thomas steps down. And he's just like, Jim Ho, please come to the principal's office where the court can call you on the carpet. But that's the whole vibe. This is an entire appellate court filled with people who are auditioning for the Supreme Court, and they have no incentive but to be as extreme and outlandish as possible. And they do. And the court has to take these cases because they have to sort of set it right. But even as they try to set it right, they are actually setting it to the right.
I mean, just to underscore that, Melissa, in other terms, I have felt like Roberts had an awareness that the Supreme Court's approval rating is at this record low, and some sense of like, okay, we're going to end the term with some like wins for the liberals, right? So that the headlines are going to be some on this side, some on the other side. There is so little of that this term, so little. And that's part of why I was surprised by Roberts picking absolute immunity and lots of immunity for former President Trump as his cause, because it just seemed like on top of everything else, it was like spending the court's capital on a cause that I did not understand that he fully subscribed to, although now you guys have set me straight as to why. And you're right about, altering democracy, Melissa. Like, I absolutely and it's not that I ever thought that Roberts was a moderate. It's just that this opinion, oh my God, it's so troubling for rule of law, for the actual dangers the country faces.
If you think about what were the, quote, wins, unquote, for, left-leaning folk at the Supreme Court this term, they all fall into one of two categories, either punts or cases where the Fifth Circuit was just so crazy that the Supreme Court couldn't actually abide it, right? So you get both of them in the Mifepristone case, right, where it's a punt because the Fifth Circuit was too crazy, right? You get that in the EMTALA case, the CFPB case, like, hey, congratulations, consumer protection actually, and we're not going to bring down the entire Federal Reserve in one decision. I mean, for reasons I don't fully understand, I was on the Hugh Hewitt show with Jonathan Adler last week, and Jonathan, who's a professor at Case Western, described the court as center-right. And my question is, what center are you starting from? Like the center of, Barry Goldwater's election campaign? I mean, there's nothing center about it. And I think the sooner that folks accept that, the sooner we can talk about what we do about it.
It's now time to take a moment for our sidebar feature, which explains some of the issues and topics that are prominent in the news. Today's sidebar feature explains the right against self-incrimination and the nuances of our Constitution's Fifth Amendment's protections. And to explain this topic, we welcome Sam Morrell. Sam Morrell is a comedian known for his role as a regular on Comedy Central's This Week at the Comedy Cellar and his recent Netflix special, Sam Morrell, You've Changed. I give you Sam Morrell on our right against self-incrimination.
The Fifth Amendment guarantees that no person can be compelled in any criminal case to be a witness against himself, but there are legal nuances concerning what the provision has been held to cover or not cover. The core privilege of the Fifth Amendment, which applies in state and federal prosecutions, means that a criminal defendant cannot be forced to testify, and the judge must instruct the jury that it cannot hold the decision not to testify against them. Moreover, a prosecutor cannot comment to the jury on a defendant's decision or prospective decision not to testify. Likewise, the Fifth Amendment means that a person has the right to remain silent when questioned by the police. The privilege can be waived, but the waiver must be knowing and intelligent. The famous Miranda warnings, while not explicitly constitutionally required, have become the universal warning that the police must provide to a subject in custody in order for the subject's statements to be admissible. There are multiple exceptions to the Miranda principle, most importantly if the speaker agrees to waive the right not to speak and a subject who is not in custody who decides to offer information has not been compelled to be a witness against themselves and their statements are admissible. Finally, there are many situations in which police need not give the warnings, such as when public safety is at risk. The Fifth Amendment is not a complete right not to testify, only a right not to testify against yourself. Thus, a witness who has been granted immunity under federal law, typically combined with some guarantee of non-prosecution, snitch, may be forced to testify against others under pain of being held in contempt. There are several limitations to the Fifth Amendment guarantee. For example, it only applies to testimonial evidence and thus not to physical evidence such as blood or DNA tests, socket murderers, and in some cases computer passwords which can be ordered to be produced notwithstanding their likelihood of incriminating the subject. And it doesn't apply to the production of documents unless the very act of production would be incriminating. Also, it applies to persons, not corporations, or other artificial entities. Finally, even apart from the Fifth Amendment protection against self-incrimination, the Constitution forbids the use of some involuntary confessions, for example, confessions extracted through torture, but don't tell that to Dick Cheney. Pleading the Fifth only really works under certain circumstances, doesn't work great with your girlfriend. For Talking Feds, I'm Sam Morrell.
Thank you, Sam Morrell. Sam is currently on tour, and you can find show and ticket information at www.sammorrell.com. That's www.sammorril.com. All right, it is now time for a spirited debate brought to you by our sponsor, Total Wine and More. Each episode, you'll be hearing an expert talk about the pros and cons of a particular issue in the world of wine, spirit, and beverages.
Thank you, Harry. In today's spirited debate, we uncork the notion of drinking bottled wine versus canned wine. Yeah, wine in a can. Wine connoisseurs may stay true to the bottle, but wine connoisseurs have adopted the untraditional packaging for its added convenience, ideal for picnics, concerts, and outdoor events, really anywhere corkscrews are scarce. And since aluminum cools faster than glass, it reduces the time it takes to chill your favorite Sauvignon Blanc. But swirling your wine in a glass does help it open up, which gives it a lot more flavor. Of course, you can always transfer your canned wine to a glass, but if you're looking to experience the subtleties of a nice bottle, drinking from a glass adds a lot. There are wines more suited to the bottle, and there are those well suited for the canned life. Crisp and sparkling whites and rosés in particular tend to fare best in cans, but bigger, bolder wines will usually benefit from a nice glass. It would seem both have their place. Still on the fence between bottles or cans? There's always wine in a box.
Thanks to our friends at Total Wine and More for today's A Spirited Debate. I want to try to sum it up a little. By the way, Melissa, the point you made, it really struck home. I think it's circumstantial, but pretty quiet, powder dry from Kagan at the very end. I think it's the way the assignments came out, but you might have thought that she would lock horns more with Roberts. Let me just ask, the immunity opinion, is it in fact, as Steve has written, the most aggressive restructuring of the federal government, not just in our lifetimes, but maybe since, Marbury versus Madison? And where is there left to go after a term such as this one?
This court is an imperial court. It's given us an imperial judiciary, which, thanks to Donald Trump, is stocked with a lot of movement conservatives who are bent on deregulation. And with this immunity decision, it is poised to give us an imperial president. The one branch that has not been imperialized here is Congress. And not surprisingly, that is perhaps the branch closest to the people themselves. That's all you need to know.
Harry, I would love to get your thoughts about what you think is going to happen next when this case goes back to Judge Chutkan's district courtroom.
This is where their guidance is really cryptic and incomplete. So what's going to happen next? Several things, it seems to me. In other words, there's no prospect of a clean application here because anything she does, you know that Trump will fight. There are certain things that the court have as much as ordered her to cleave off from the case, and maybe that Jack Smith will do as well. But there's quite a lot of middle ground in this murky category of not Article 2, not core exclusive powers, but still official powers. The court said next to nothing about what is an unofficial act, and I think has opened up the door for Trump to claim anything as a potential unofficial act, which has the not insignificant consequence of making Jack Smith bear the burden of showing this couldn't implicate the authority of the president. So I think everything with DOJ is gone. It seems like much of what's with Pence is gone, and maybe the ellipse is gone, but maybe the fraudulent certificates are in. But that, whatever she says, will then go, I think, inevitably up again.
My view on this, Harry, is slightly different because the election's going to happen before any of that, right? And if Trump wins, we never get that far, right?
So do you think no evidentiary hearing about like the fraudulent elector scheme before the election?
I don't know what the factual disputes are. Like what really has to happen is a series of legal determinations. First, I assume Jack Smith is going to file a superseding indictment.
He has to.
And then the question's going to be like, do each of the charged acts in the indictment fall on the right side of the line? And if the answer to that is yes, then the question is, is the evidence Smith plans to use to substantiate those charges on the right side of the line? I just don't see how any of those are going to come down to factual disputes because, ironically, I think what the Supreme Court was trying to avoid was resolution of factual disputes. That's why they cut out motive. And really just like, if this is the evidence you're using and these are the charges, can the case go forward? That's the question. And there's no way that gets conclusively resolved by November.
But not only that, how does it get conclusively resolved? Because I know there's a lot of attraction to this possible evidentiary hearing idea where you put Pence on the stand and ask these questions and at least get some holding that it was an official action. But I'm not very bullish on that. First, for the reasons Steve is saying, but also it's the sort of number one hole or circularity in the court's opinion. We call Vice President Pence, Your Honor, well, wait a second, you're going to be talking about official action here, so you can't, there's what comes first, the determination of official action or not. And they haven't clarified that, and I think Trump will be able to sort of freeze things out and have that go up. But then second, I see the argument for it, but we've already had a few opinions from courts saying, for example, the crime fraud exception applies, meaning that it's probable that Trump committed a crime. And they didn't really have a big effect on the electorate. What she could decide here at most is this was official conduct. I think viewing that as sort of a proxy for, or even a near proxy for what you would want to establish in a trial is just putting too much stock in it. I don't think it'll hit home in the same way with the American people and untelevised holding that this was official action. It's the action that it was, official or unofficial. Was it criminal?
I don't have high hopes for what might happen in the sort of truncated evidentiary hearing, but I do think going into the election, to the extent that the American public had been counting on a public trial by jury to ventilate some of these questions and to allow them an opportunity to decide for themselves what they thought about it, this could be an important forum for doing that. I mean, I will also note, and this is not a plug for the book, but all of the indictments are available. And granted, this is just the prosecution's theory of the case, but I think reading the indictments and recognizing that most prosecutors do not bring cases without some sense that they can back up their allegations with real proof in open court would be useful for many Americans who are really struggling with what to do and how to make sense of what happened on January 6th and what it means for November 2024. And I think a public hearing, even if it is only an evidentiary hearing where you can present this evidence, where individuals can provide their testimony, would be an important complement to the American public having that limited engagement with these questions in lieu of an actual criminal trial.
I don't disagree that having Mike Pence come to the stand or Pat Cipollone or others and actually give evidence, that would be an arresting moment, more even than the holding. I'm just not sure how, in the face of efforts to keep that from happening with Trump and the absence of clear guidance from the court, that actually goes down. I certainly agree it's better than nothing. I just think that's not very much time to happen, and for, in part, the reason Steve is saying, it's just not a clean path. Chutkan will allow it, and then I think there'll be an immediate appeal, and it's easy enough with the absence of guidance from the court to tie this up in knots even more. All right. Do we have any cheery notes to add in the last 90 seconds? Does this become the signature now case of the Roberts court, and does it kind of lay waste to the idea of Roberts as a statesman looking to mediate somewhat in view of the court's low public opinion?
I think the answer to the latter question is absolutely yes. John Roberts, statesman, R.I.P. I think to the former question, it's too soon to tell. I mean, first, the Roberts court isn't ending tomorrow. And, at the rate we're going, it could have a lot to say about the fall election cycle at this rate. Second, I'll just say, in a world in which President Trump somehow gets elected this November, I think our conversation about the Supreme Court is going to get a lot trickier, because I think a lot of us are going to view the court as flawed and imperfect and unaccountable as it is, as perhaps the only institution in a position to actually meaningfully stand up to a Donald Trump in a second term. And, in that universe, I think there are going to be even more important decisions coming down the pike than the immunity case, at which point I think we're going to be asking serious questions about whether the court should have been more long-term in its thinking about the importance of preserving its credibility for moments when it needs to hand out unpopular decisions. I still think the moment of the term was actually back in January, when a 5-4 majority let, Biden remove razor wire along the U.S.-Mexico border, and Chip Roy went on national television and told Governor Abbott he should defy that decision. Look how quickly the far right wing of the Republican Party was willing to turn against the Supreme Court over not even a national issue, over what one state was doing along the border. We're in for more of that in a second Trump administration. And I think my concern is that Trump versus the United States is looked back on historically as a self-inflicted wound where the court had a chance to actually build credibility and will be seen in the long term as having only further accelerated its erosion.
All right. Thanks very much to everyone. And there's going to be quite a lot to unpack going forward, but this has been a colossal week by any measure. We are out of time. Thank you so much, Emily, Melissa, and Steve. And thank you very much, listeners, for tuning in to Talking Feds. If you like what you've heard, please tell a friend to subscribe to us on Apple Podcasts or wherever they get their podcasts. And please take a moment to rate and review this podcast. You can also subscribe to us on YouTube, where we are posting full episodes, talking books, and bonus video content. You can follow us on Twitter at Talking Feds Pod, and you can look to see our latest offerings on Patreon. Talking Feds is a completely independent production, so if you like the work we do and are inclined to support the show, joining our Patreon is the best way to do it. Thanks for tuning in, and don't worry, as long as you need answers, the Feds will keep talking. Talking Feds is produced by Catherine Devine, associate producer Gabriella Glick, sound engineering by Matt McArdle. Our research producer is Zeke Reed. Rosie Dawn Griffin and David Lieberman are our contributing writers, and production assistants by Akshaj Turbailu and Anna Salvatore. Thanks very much to Sam Morrell for explaining the right against self-incrimination. Our music, as ever, is by the amazing Philip Glass. Talking Fez is a production of Delito LLC. I'm Harry Littman. Talk to you later. Now it's time for a new section of the show, Talking Back. This special segment will feature a question of the week that we've crowdsourced from our Patreon members. If you like the work we're doing at Talking Feds, joining our Patreon is the best way to support the show. And now you'll have the chance to get your question answered on next week's episode. So, check out our Patreon link in the episode description. It only costs $5 to join. And now for this week's question.
Hello, Harry. This is Will Gibson. How can, in a state court in New York, Judge Merchan decide that he's going to stay any decision on that case because of supposed actions taken by Trump before he was president, therefore not official, and in a state action rather than a federal?
Thanks, William. You're certainly right that almost all the action in the New York case took place before Trump even was president. But there were a number of actions to complete the crimes that he did as president, such as signing the checks. Those also, it seems to me, Justice Merchan should easily be able to find are unofficial. But the Supreme Court has laid another trap in the U.S. versus Trump case, saying that the government cannot offer evidence of an official action to prove an unofficial action. In other words, there could be no immunity for the crime because it's an unofficial action, and yet the opinion limits how the government can prove it. And because in the New York case, there were a few items of evidence that Trump at least can argue were official actions, namely his conversation with Hope Hicks. Remember, Hope Hicks offered fairly devastating testimony of just how Trump world was shaken up by the revelations of Stormy Daniels, and a couple of his tweets he could argue constitute official action, and therefore we'd have to figure, were those pieces of evidence important to the ruling, or are they what the lawyers call harmless error? So even though I agree with you, it's almost all action before he was president, and all of it, even after he was president, seems manifestly unofficial. There's a little bit of cleanup work to do about whether evidence was introduced that had an important enough effect that it would require a retrial. So that's how the DA came to say, we don't think there's any merit there, but we agree you have to take a couple months, and that's why the sentencing has been moved from July 11th to September 18th. Good question. Thanks for asking it.